Twitter beef takes on a whole new meaning now. With more on what's ahead, we welcome in Boston College law professor Brian Quinn, who focuses on corporate law as well as M&A. Brian, good to see you. That precipitous drop that Jared just mentioned in the Twitter stock, do you think that factors in here at all as we move into this trial in Delaware?
Well, no, I don't think the stock price is going to really affect the legal arguments that are going to be made in the courts in Delaware. The real focus is going to be on the contract and the way the parties acted with respect to the contract. That's going to be the focus of the courts.
As we look inside this case, then, what will it primarily hinge on, and what does each side need to prove?
Well, the burden of proof here lies with Mr. Musk, since he signed this contract, and the Delaware courts presume that people who sign contracts do so for a reason. And if he wants to walk away, he's going to have to prove his case, which means that he's going to have to prove that, in fact, Twitter did violate the terms, that they're in breach. And he's laid out three different arguments, and we'll see what the court says with respect to each of those. And
Brian, we hear in particular about the term material adverse effect. That's what's been cited by Elon's lawyers. How does he prove that, and do you think he can?
Yeah, that's going to be a very, very difficult claim to win on. In fact, in all of our history with respect to these kinds of claims, it's only ever succeeded once. That was in 2018, the Acorn case. So I don't expect that that's going to be the kind of claim that's going to succeed. So he can make that argument, but more often than not, when people bring in one of these MAE arguments, it's as a way to generate leverage for a renegotiation on price.
Now, as we know, Musk is saying the reason he's pulling out of this is because he's not getting sufficient information on this. But you've said he can't use unreasonable information requests to create a pretext to then claim a violation. How much of a leg does he actually have to stand on based on how he's performed so far?
Yeah, it's a little bit like, Claude Rains wandering into Rick's Cafe in Casablanca and being shocked that there's gambling going on, right? One of the reasons why he did this deal was to take care of the bots problem. I think it's one of the first things he said about Twitter when he acquired it or when he signed the contract or made the offer. So it's kind of disingenuous, I think, right now to say, oh, geez, there are bots, so I can't do this deal. So it's a hard argument to make, but it's one that he's certainly going to try.
And given that, he waived so many of his rights to begin this process, how will that impact the trial? And ultimately, do you think Elon can be compelled to buy Twitter?
Right. So he did waive due diligence. He made an offer, sent over a draft merger agreement, asked them to sign it, which they did. The Delaware courts will treat buyers who are represented by sophisticated counsel, advised by investment banks on Wall Street. They'll treat buyers as big boys and girls. And if you sign a contract, courts are generally going to hold you liable for that contract. So he has a very uphill road to hoe here.
And in terms of perhaps any sort of way out for Musk in this, in terms of either renegotiating the price, paying the breakup fee, or perhaps getting out of this deal without a breakup fee, what do you think is more likely?
So I think there are probably, there are the three options here, I think, that are realistic. One is a discount on the price. The problem with the discount on the price is likely the Twitter board's going to be amenable to something like 50 or 49 or some marginal number like that. And he's going to be looking at 30s, in the 30s. If the difference is that big, I doubt very much that the Twitter board's going to go for it. A second option is that the court compels him to complete the transaction, which courts in Delaware have done in the past, and they are not adverse to doing that at all. So if he loses, he could face an order from a court to complete the deal. And a third outcome is that in fact he wants to walk away, and they want him to walk away. At which point they negotiate a settlement. It's not the $1 billion price; it'll be somewhere upwards of that. And I would expect if I were the board of Twitter, I might say, the price is 54. We're trading at 34. Give us $20 a share, and we'll let you walk away. That's the kind of negotiation that'll go on.
One thing we can count on is Elon making things harder for himself. He's already done that, perhaps with this meme he tweeted. They said I couldn't buy Twitter. Then they wouldn't disclose bot info. Now they want me to force me to buy Twitter. Now they have to disclose bot info in court with the pictures of him laughing. If you're his lawyer, what are you telling Elon at this point?
Yeah, I'd be very careful because it goes both ways. I mean, he'll get discovery on Twitter, but then they get discovery on him, and they're going to say, "Hey, Your Honor, it's all just a pretext. He didn't want to do this deal. Let's look at some emails, and that'll be a problem for him if that kind of evidence turns up.
And in terms of what you can compare this case to, obviously, Twitter wasn't even looking to sell in the first place until Elon came along and said he wanted to buy it. Is there anything comparable to this kind of case that we've seen, or how much of a landmark do you think this case might be?
Oh, I don't think it's going to be much of a landmark in the end. These kinds of cases or these kinds of disputes, they happen all the time. Buyer buys a company. Day after they buy the company, they realize, well, geez, I paid too much, and they try to find a way out. Courts get involved, and the parties renegotiate a price. We've been down this road many, many times to date, and I'm sure we'll go down this road again sometime in the future, but probably not with these parties.